Court overturned the Arizona death penalty system, similar to Florida's, but not the same. Susan Clary, the Orlando Sentinel, joins us now with trying to help sort through this. Susan, thanks for being here.
Hi, Scott.
What the justices did is say that the judge can't impose sentence. The jury has to do it, essentially. Is that right?
That's true. In Arizona and 4 other states, they have a system where the jury decides conviction or acquittal, but the judge decides the penalty, and the Supreme Court said that that violates the 6th Amendment.
The jury has to be, a jury of your peers has to make that decision.
That's true.
Now, in Florida, it's the same thing, only different. In Florida, as we well know, as we've followed over the years, if someone's convicted in a capital case, then there is a second trial, so to speak, and the jury does consider, and the jury makes a recommendation. But
that's true. That's called a hybrid system. There are 4 states
that do that?
That have that.
So what does the Supreme Court ruling mean here? Anything, or does anybody know?
Well, it was debated a lot yesterday between defense attorneys and prosecutors. One thought is that it will only affect 10 of the 370 people we have on death row now who are on death row because a judge overrode a jury's decision for life in prison. In other words, the jury went through the sentencing phase, decided for life in prison, and the judge overrode that decision, and the person is on death row. That affects 10 of our inmates. However, there's also an argument that it could affect all 370 because a lot of them are on death row through verdicts that were not unanimous in the sentencing phase. So it's because Arizona is different, and because this decision deals with Arizona's death penalty system, it's unclear how it will affect Florida, if it affects Florida at all, or it could affect everyone on death row in Florida. It could also affect the statutes in Florida, because it appears now that a portion of our statute is unconstitutional, and the legislature may have to rewrite the statute.
Somebody's going to have to address the death row cases. Are the defense attorneys going to take it to the court, or what's going to happen here?
2 things will happen. I think there will be litigation before the Florida Supreme Court. There will absolutely be appeals. None had been filed yesterday, the Attorney General's office said. However, they expected appeals to come. And it's going to be through litigation that we're going to determine what will happen in our state with our death penalty laws. Anything
more from the High Court, the U.S. Supreme Court? Will they rule on the Florida situation, or will they just let us sort it out?
It's unclear whether they'll rule on the Florida situation or not. However, in anticipation of this decision in Ring versus Arizona yesterday, the Supreme Court stayed 2 executions in Florida. That of Lynroy Bodison, who was accused of murdering in 1979 the Eatonville postmistress, and Amos King, who's accused of a murder in Tarpon Springs. The Supreme Court will decide on Thursday whether to hear those cases or not. So that may send some sort of signal to Florida about what this will mean for us.
Thank you, Susan. Susan Clary, the Orlando Sentinel, trying to help us sort out what yesterday's United States Supreme Court decision on the death penalty may mean in Florida. Reporter Susan Clary was in federal court following the hearing. She joins us from the Sentinel newsroom now with the details. Susan, thank you. Tell us a little bit about today's sentencing.
Well, this was a continuance of a sentencing last month that started in February, and then it finished today. And St. Natus appeared in court today, and he was very quiet. He didn't speak for most of the hearing. Judge Patricia Fawcett, Assistant U.S. Attorney Matt Perry, and his attorney Mike Nielsen talked about how many years he should be sentenced to, if the years should be stacked. And amidst that, St. Natus stood, pounded his fists on the table, and cried out, "It ain't my fault, it ain't my fault," and the U.S. Marshals had to restrain him and sit him down. He very much wanted to make a statement to the judge today, but because he faces a state trial on the murder charges, his attorney would not allow him to.
Right, the federal charges were all on the events surrounding the actual shooting. The actual murder charges is not a federal charge. That'll be in state court later, will it not?
That's true. He faces first-degree murder in the death of Orlando police officer George DeSalvia, and attempted first-degree murder in the injuries that Eddie Diaz suffered. Eddie was paralyzed and lost the use of his legs, though he is walking with a cane now, and he was in court today. That trial is expected to begin on May 7th, and St. Natus faces the death penalty in that case.
Sentinel court reporter Susan Clary joins us from the Sentinel newsroom. Susan, how long is the criminal investigation, and how long did it take the government to present its case?
The insurance company collapsed in 1994. The criminal investigation was 5 years in the making. Dozens of people and corporations were indicted. Many pleaded guilty. These 5 chose to go to trial beginning February 1st. So this has been a 9-month trial.
Not surprising, I guess, a 2-week deliberation process. Then what was the jury's decision?
The jury convicted Shalom Weiss, the lead defendant, on all counts. One defendant, Richard Herman, was acquitted, and 3 of the others were found guilty on various counts.
Now, what is the story here? One of the defendants is missing. He sat through most of the trial, and now he's missing?
Shalom Weiss, the lead defendant in the case, disappeared the day the jury returned to begin deliberations on October 18th. He has not been seen, and the FBI is searching for him.
What's next in this case?
Scott, tomorrow the jury returns at 9 a.m. to deliberate on forfeiture. That's the properties that would be involved in the criminal activity, and they'll determine whether the property would be taken away. And on January 31st, the defendants will be sentenced.
Quite an involved story, I imagine. Thank you, Susan.
Joining us now with more on the proposals is Orlando Sentinel court reporter Susan Clary. Thanks for joining us, Susan.
Hi.
Susan, now why is there a need for jury reform here in Florida?
Well, I think the feeling in Florida is that jurors are treated like children or passive bystanders, that they're not really part of the system, and the effort was to make them full partners in the court system.
So what information was examined in the reports and creation, and who was responsible for gathering this whole thing?
Well, about 18 months ago, they formed a committee made up of lawyers, judges, former jurors, court administrators, judicial liaisons, and those people got together and talked about the different changes that needed to be made and the different additions for jurors in the state of Florida.
So what were some of the proposed innovations here? What are we looking at?
Gosh, everything from increasing the pay that they get per day, to paying their mileage, to paying for refreshments, to allowing them to take notes during trials, allowing them to ask questions of the witnesses through the judge, allowing them to ask about the law and how they should proceed with deliberations, basically treating them as if they are full partners in the trial, and allowing them to feel freer to participate in the best way they can to come up with the best verdict that they can.
So is Florida the very first state to implement jury reform? I would think not.
Florida is not the first state. Actually, Arizona was used as a model for our committee to determine what changes needed to be made. And while our committee was meeting, 7 other states were meeting. Another model that was used was New York. New York has implemented jury innovations, and one of the most important ones in New York was to abolish the exemption. That is, people are allowed to get out of jury duty for certain positions that they hold: lawyers, judges, governors, legislators, and famous people use that as an exemption, and so they abolished that. And in New York, Mayor Giuliani, a former Governor Pataki, Dr. Ruth, Robert De Niro, these people have all been called to jury duty since the innovation was created to abolish an exemption. So a lot of changes have happened in other states.
So when would these new rules take effect here in Florida?
Well, the rules that apply to the court system that aren't monetary would probably be ruled on by the Florida Supreme Court in the fall. They're going to take it under consideration. They're going to ask for opinions from the Florida Bar and other interested parties. There will be oral arguments, and then they'll vote. And the monetary changes will go to the legislature next January. So it'll probably be quite a while before we see these innovations implemented in Orange County and Central Florida and all over the state.
At least a year. Okay, well, thanks a lot, Susan. Good talking to you today. Sentinel reporter Susan Clary was in the courtroom as the trial began. She now joins us with more on this story. Thanks for joining us, Susan.
Hi, Rod.
So now tell us, what can you tell us about this case anyway?
Well, the Watson family, Peggy and Lorenzo Watson, ordered a pizza from the Port St. John Pizza Hut on August 14th, 1998. Actually, their daughter placed the order, 16-year-old daughter. And the pizza was delivered, and they paid for the pizza and closed the door. A few minutes later, the delivery person knocked on the door and said, "I'm sorry, I couldn't let you eat this pizza without seeing this receipt," and showed them this computerized receipt from the Port St. John Pizza Hut that had a racial slur written on it. The family was very distraught. They were very upset. They called the Pizza Hut. Pizza Hut has said that in the ensuing days, the manager apologized. The regional manager apologized. They offered to take the family to dinner, and they fired the employee who was responsible for putting this on the receipt. It was placed in a part of the receipt where generally you would see yellow house on the left, red car in the driveway, instructions for the driver to deliver the pizza. The family was not content with what Pizza Hut had to offer, and they filed a lawsuit.
So has the family testified yet at all? Has anyone testified?
Yes, the mother, Peggy Watson, and the father, Lorenzo Watson, both testified. Peggy Watson said that they ordered the pizza, the driver knocked on the door, and they were stunned to see this receipt. In fact, they said the delivery person was also in tears. They said that this has had a really negative effect on their daughter, Eugenia Gray, who is 18 now. She's in college. But they said that she's become more withdrawn, that she's become very shy. The receipt had the word stupid written on it, and that she's had some problems dealing with it. And so they don't feel that an apology and an offer to go out to dinner was enough. They want to send a message to large corporations and Pizza Hut that this kind of thing won't be tolerated.
Now, we also understand that a computer expert was brought in to testify. What details can you share with us on that?
One of the contentions of the plaintiff's attorneys, Mark and Lisa Tiedig, is that Pizza Hut could have prevented this, that instances like this have happened before, and that Pizza Hut could have instituted a filter system in their computer throughout the country that would have kept certain words from being printed on the receipts. For instance, when somebody enters an address into a Pizza Hut computer and the address isn't part of the delivery area, it rejects that. So the contention of the plaintiff's attorney is that Pizza Hut could have instituted a similar filter system in the area where the descriptions about the house went to avoid such epithets and slurs and bad words on these receipts. Now, the defendant's attorney, the Pizza Hut attorney, contends that that's not true, that couldn't have been done, and so it will continue with this kind of testimony.
Okay, well, thanks for the update, Susan. Good talking to you today.
Great.